Okay. Good evening, everyone. We are very honored today to have Mr. David Quest, KC, with us here today to speak to us on the topic of arbitrating smart contract and crypto asset disputes. David is a leading commercial silk, practicing across the whole range of commercial disputes, with a focus on banking and finance, commercial and financial fraud, investments and joint ventures, international trade, technology and computing, insurance and reinsurance, and professional negligence. David is one of the very few barristers with real expertise, both technical and legal, in crypto assets. He is a lead author of the landmark legal statement issued by the UK Jurisdiction Task Force entitled Legal Statement on Crypto Assets and Smart Contracts. The legal statement sets out the law on the proprietary status of crypto assets and the enforceability of smart contracts. And the statement has been endorsed by the courts in England, particularly in some very famous case like the AA and Persons Unknown, and also in other cases around the world. He is also the lead author of the UKJT Digital Dispute Resolution Rules, which is a groundbreaking rules setting out the certain arbitration rules aimed at digital transactions. Now, during this presentation, may I remind the participants that this webinar will be recorded. The recording will be uploaded to the website of the Hong Kong Institute of Arbitrators and also to the YouTube channel. Normally in our webinar, the raise hand function and the chat function will be disabled. But in this particular webinar, David told me that the audience are free to raise any questions anytime during his presentation. So if the participants have any questions, they can either raise it during the presentation or they can type their questions in the chat box. We will then answer your questions afterwards. One CBD points has been applied for. So this webinar will have one CBD points awarded by the Law Society of Hong Kong. And may I also remind the attendees to submit their evaluation form to us after watching this webinar. So please join us in welcoming David. David, the floor is yours.
Thank you very much. And yes, do indeed, please, if you've got questions or comments or anything you want to say as we go along, do feel free to raise them in the chat or in the Q&A, and I'll try and pick them up as we go along. I got interested in this area of crypto assets in about 2015 when I started reading and writing about crypto assets. And something I always think that if only I hadn't read and wrote about them, but instead had just bought them in 2015, I probably wouldn't need to be here. But there it is. We only need to look at the news in the last few days to see how economically significant this area has become. You've already read about the collapse of FTX and the enormous potential there is for disputes. But before we get on to disputes and in particular the part that arbitration has to play in these kind of disputes, I wanted just to start with a sketch of the world of crypto assets and smart contracts for the benefit of those who may not be entirely familiar with them. The genesis of all of this is back in the mid-1990s, actually, when the US National Security Agency, their cryptology division, published a paper just about the time when electronic commerce on the internet was taking off. And they proposed using cryptographic techniques to create an electronic payment system where you would have digital tokens, electronic tokens, taking the place of physical coins and notes. Now, there's of course nothing novel about having an electronic payment system. Electronic bank transfers have been around, for very many years. But the point about bank transfers and bank transactions is they all take effect as credits and debits on accounts. And so the entire system is dependent on the involvement of banks as trusted counterparties and as payment intermediaries and generally as parties who sort of keep the books and affect the payments. And the idea, or the original idea behind cryptocurrency, was to dispense with intermediaries and to create a system that was entirely decentralized. Didn't need banks, didn't need anyone in charge, didn't need anything. Now, as you all know, the first implementation of cryptocurrency was Bitcoin in 2009. And there's a famous, it was introduced by a famous white paper published by the pseudonymous Satoshi Nakamoto, the inventor of Bitcoin, whose identity remains unknown. Bitcoin remains by far the largest crypto asset system, with about 40% of the total market capitalization, which even following the kind of latest crashes is still about $800 billion in total. So it's a big market, crypto assets. And I'm going to talk, just by way of introducing some of the concepts, a little bit about Bitcoin. But of course, what one bears in mind, it is just one of many different kinds of crypto assets. Now, just thinking about crypto assets as currency for a moment, two important features of regular coins and notes is, first of all, I can't spend a banknote unless I've got it. And second, once I've spent it, I can't spend it again because I haven't got it anymore. Now, those sound like obvious things, and they're both consequences of possession. But they're a kind of critical feature in the operation of normal money. And one of the main problems of crypto assets is because digital tokens are just data constructs. They're just data. They can't be possessed, or at least not in the same way as regular banknotes can. So one of the fundamental problems of crypto asset systems is how to ensure that people can only spend their own digital assets, not other people's. And that's done using digital signatures, and that's why it's crypto. And to take Bitcoin as an example, but the same principle applies to most kinds of crypto assets. Each Bitcoin is linked to an address identifier, which is just a string of letters and numbers, a little bit, one can imagine, like a kind of numbered bank account. And each address identifier has with it a private key, which is a code generated at the same time as the address and known only to the creator of the address. And any transfer of Bitcoin or another crypto asset from one address to another has to be authenticated by digitally signing it using the private key. And so what that means is that you can control the crypto asset at a particular address if, but only if, you have, or you know, the private key. So knowledge of this secret code, of this private key, becomes, in the crypto asset world, the legal equivalent of physical possession of a physical coin. And it means, for example, that if you lose a private key, then the asset is lost too. Or if you don't have access to the private key, then you don't have access to the asset. And there's no way around that. There's no way of recreating the private key. Some people say, well, where do these addresses come from? How do I get one? How do I start this process in the first place? And again, a sort of critical aspect of these decentralized systems like Bitcoin and Ethereum is that you can create an address and participate in the system without getting any approval from anyone else. They're not issued by some central body as a bank account. Anyone can create their own address, essentially using just a piece of software. And I mean, I can actually, it's sometimes quite interesting. I can actually, I hope I can share my screen, show you this process. So, so this is just a website, free website you can go to, and what it does is it uses random numbers which we generate just by moving the mouse on the screen, and when it's got enough randomness, it generates on the left the number which is an address identifier which I can store my Bitcoin or my digital assets, and on the right the private key which gives me control of them. And that's something I've done myself without the involvement of anyone else. Once I've got these, I can start using digital assets within the Bitcoin system. I didn't need to do any KYC. I didn't need any approval. I just did it myself with a piece of software. So that's what I mean about the whole system being completely decentralized. And also, you will see it's an anonymous process. I didn't have to give any identity information in order to create that address and get my private key. And again, that's a key characteristic of most crypto asset systems, that they're anonymous. You can't go behind the address and find out who created them. So that's one side of it. The transactions need to be digitally signed with the private key. And the other aspect is what's called the double spending or the double transfer problem, which is how do we ensure that if I've got a Bitcoin or a crypto asset and I use my private key to transfer it to someone else, what stops me doing that again? What stops me then purporting to put sign another instruction, purporting to transfer the same thing to someone different, which obviously be fraud. But how do you stop that? And that is addressed in all crypto asset systems by keeping a public ledger of all transactions, so that everyone can see just by looking at the ledger whether a new transfer is inconsistent with something that's gone before. And the usual format of these public ledgers is blocks of transactions linked together in a chain, and that's why we call it a blockchain. And again, we can see how this actually works in practice by, again, if I can just share my screen, by looking at the blockchain in the Bitcoin system. What we're looking at, or what you should be able to see on screen, is a presentation of the public data in the Bitcoin blockchain. This is not an official website in any way, because the blockchain is public, and so everyone can look at it. But we see, for example, here's the most recent block on the chain, and it has within it a whole series of transactions, and each one we can see. Let's take this one, for example, that we have 0.002 Bitcoin being transferred from one address to on the left to two addresses on the right. And this is, as one sees, this is in some ways a entirely public system, because every transaction, it's all laid out for us. We can see how much is being transferred and from which address and to which address. But on the other, so it's in one sense public, but in another sense, it's completely private, because we can see this being transferred, but we have no idea, no way of finding out who it was who created this address here. And that information is not stored anywhere on the blockchain. Now, one might say, well, this is interesting, but as I've said, this is a public process and no one's in charge of it. Well, if that's right, then who is responsible for keeping this ledger? If the system is entirely decentralized, and the answer, somewhat surprisingly, is that no one is. Anyone can keep and update their own copy of the ledger and distribute it around the network with their own transactions in it. But then how does one know which version of the ledger is definitive, and how do you stop people changing it? And that's really the central problem in crypto asset systems. How do you have a public system of transactions with no one in charge, which nevertheless can be reliable in some way? And there are various different solutions that are proposed for that. The solution in the Bitcoin system is to make it very difficult, deliberately extremely difficult, to create a new block of transactions on the blockchain. And the way the Bitcoin system works is you can, I showed you the data for the transactions that we see on the blockchain. But the only way to create a valid block of transactions that everyone else will recognize in the Bitcoin system is to solve an extremely difficult mathematical problem by trial and error, the answer to which depends on the transactions in the block. So it's a bit like solving an enormously difficult jigsaw problem, which is very difficult to do. Once you've done it, anyone else can look at it and see whether you've done it right or not. And that process, as I'm sure you would have read about, is enormously computationally difficult and expensive and uses a lot of energy and deliberately so. So it sounds strange, but deliberately so because the consequence of making it so difficult to create new blocks on the blockchain is that once someone's done it, there's a big economic disincentive to try and do it, to try and redo the block, to try and change the transactions and do another block. And the blocks kind of pile on top of each other as they're done. And that means that if you want to start changing older blocks, you have to redo that block and then redo all the blocks on top of it. So over time, it becomes more and more and more difficult and time-consuming and expensive to change what's in the blockchain. And if you do the maths after there are about 5 or 6 blocks piled on the top, it's essentially impossible to catch up and change it, even if you have the sort of resources available to, let's say, Russia. So in practical terms, this system means that after a certain number of blocks have been put into the blockchain, the data in them is, for all practical purposes, immutable. And that's what makes the Bitcoin blockchain reliable. So it's a kind of process of psychology and economics in that way, that there's a disincentive to change anything once it's got in there. Now that's not the only validation system. I mean, one of the problems with it is very time consuming and expensive. There are other methods. You may have read, for example, that the Ethereum crypto asset system has just moved from a system similar to Bitcoin to what's called a proof of stake system, where individual participants are chosen to validate blocks, essentially based on the amount of assets they hold in the system. So there are different methods of doing it, but the key aspect of all of this is that there is a public distributed ledger which has a history of all the transactions on and which can't be changed. Just to make one point clear, I mean, I've been talking sort of informally about the rules of the system. For example, the rule about how you create new blocks. These are not, however, rules in the sense that we lawyers are accustomed to thinking about it. They're not legally enforceable rules. In most of these systems, there are no contracts between the participants. Public systems like Bitcoin and Ethereum work by consensus, and they rely on the fact that each participant in the system has a practical incentive to follow the rules, not because they have a legal obligation to do that, but because if they start applying different rules, then their own assets and their own transactions won't be recognized by others in the system. So it's a kind of psychological or economic pressure for people to try and reach a consensus. That said, there are from time to time in these systems proposals to change the rules. And it may be that everyone will agree to a particular change in the rules and a new consensus will form. But since there is no central body in any of these systems which can impose rules on people or can adjudicate between them, then sometimes you have a situation where some people want to change the rules and some people don't, and you get what's called a fork in the blockchain. So you end up, in essence, with two different ledgers, two different blockchains, which have the same rules and operations up to a particular point in history. And then they split and diverge into two different sets of transactions. And in effect, you end up with the crypto asset or the cryptocurrency splitting into two different kinds. And so an example of that is, if you've read about things like Bitcoin Cash or Bitcoin Gold, those are variants of the original Bitcoin, which came about as a result of a fork in the Bitcoin blockchain, where different groups of participants decided they wanted to follow different rules. Now, what's the point of all of this, one might ask? Some people say, well, the advantage of this process and the decentralization it allows removes some of the cost and risk in using banks, and it prevents interference, or what might be characterized as interference, by national monetary authorities if you're using a non-national currency. Certainly, these kind of systems are very useful for those who, for whatever reason, good or bad, want to remain anonymous and want to retain absolute control over their assets. But it's also an interesting system for those people who are in countries where banks or national monetary authorities are perhaps unreliable or not really available. All that said, and despite the fact that Bitcoin has been running for more than 10 years now, there still isn't actually very much you can buy with cryptocurrencies, and mostly as currency, they tend to be used, as I've seen it, either for paying for cups of coffee in hipster cafes, buying illegal weapons, or paying ransoms. So as currency hasn't really taken off, but what people realized soon after it was created is that one could use these, as well as using these digital tokens as a sort of money tokens, you could also use the tokens to represent real world objects as a sort of representative thing. For example, your token could represent a share in a company, or it could represent goods in transit, or it could represent land, or indeed it could represent traditional money like US dollars, all on the basis, perhaps, that you could trade the token or transfer the token on the blockchain as a way of trading the underlying asset. And that's a really interesting and really important idea, because it opens up all sorts of important commercial possibilities. I mean, there are quite a lot of legal questions over the use of tokens in that way, including one which, perhaps the most important one, which is sometimes called stapling, which is how do you, let's say you've got a token that represents a piece of land. How do you use that token? How do you ensure that holding that token actually gives you legal rights in the land? Because ultimately it's all very well saying you've got the token, but if you want to take possession of the land, you will have to go to court and get some order from the court. And how do you set up a system which essentially means that holding the token on the blockchain is equivalent to having a legal right in the land? And that's quite a complicated legal question, and has been dealt with in different ways in different systems. But once you've seen that you can use tokens in that way, one then comes to an even more interesting idea, which was the idea that since these tokens all exist digitally, within a piece of software on a network, they could actually be traded automatically by software algorithms without needing any human input. So you could have software programs that are responsible for transferring tokens backwards and forwards between addresses, and with the tokens, whatever rights underlie the tokens. And that's where we introduce the concept of a smart contract. And that's, I'm afraid, a slightly misleading term. It was coined by a man called Nick Szabo, who was a lawyer and a computer scientist, as a way of really of capturing the idea of a system that would allow crypto assets to be transferred subject to self-executing terms and conditions. And the simplified analogy that he gave, which is always a sort of useful way of thinking about it, is the concept of a vending machine, where you put in a coin and without the need for any human intervention or human decision, you get a bar of chocolate out of the machine. And the conception of a smart contract is that process, but in software on a blockchain. In other words, you put some input into the contract, and without the need for any human intervention, it then waits for certain conditions to be fulfilled. It follows its programming, and when the program tells it to, it exchanges tokens on the blockchain. It transfers Bitcoin. It receives some land token, whatever it is. So I mean, to take an example of a real life smart contract would be, let's say, a trading system that would automatically exchange a money token, a cryptocurrency token, for a goods token. And one can see how interesting that would be in international trade context. For example, where one subsequently, presently sort of rather dependent on things like letters of credit as a way of making sure that the price is paid if the goods are shipped and vice versa. But if that could be done automatically by an exchange of tokens on the blockchain, that's a really interesting idea. So an example of something I've actually been working on quite recently of a more sophisticated smart contract is one which gave rise to some real legal problems, is a trading algorithm which allowed people to trade cryptocurrencies and foreign exchange against each other. But rather than you being linked up with another human counterparty, the smart contract program had access to its own liquidity. It had control of assets on the blockchain, which gave it liquidity and which enabled it to trade effectively in its own right with counterparty traders. So those people who were trading crypto assets with this smart contract were not trading against a human party. They were just trading against a piece of software. And you can imagine the kind of interesting issues that gives rise to when, as one might think is inevitable, it turned out it was a bug in the code and the trades didn't turn out as people had expected. So that brings me to the question of the sort of main question in the talk, which is disputes in crypto assets and what part arbitration might have to play. I mean, first point, there will obviously be a lot of disputes where the subject matter of the dispute is a smart contract or a crypto asset, but the dispute itself is in reality a conventional contractual dispute, and those kind of disputes will be resolved in the ordinary way, and there's nothing particularly novel about that. Oh, by the way, I'm just going to, again, something I forgot to show you. For those who are interested in seeing, I mean, I talk about smart contracts, what one actually looks like. I mean, here's an example of what a smart contract looks like in terms of coding. You should see on the screen there. This is a contract written in a language called Solidity, which is specially designed for smart contracts. And you can see this is a contract to implement a blind auction. And you can see, that when we talk about smart contracts, that's what it looks like. Well, at least that's a human readable code, and that will then get compiled into computer executable instructions on the blockchain. I think where it gets really interesting is when you've got a dispute about the operation of the contract itself. So perhaps there's an error in the code, or the contract operates in a way that one party didn't expect. Perhaps he says the code hasn't been properly implemented, or perhaps he says that there's something outside the code itself which entitles him to be relieved from some of the effect of the smart contract, misrepresentation, illegality, whatever it is. But in the meantime, the smart contract is churning away, doing what its programming says it should do. And let me just introduce at this stage the body in which I have a particular interest, which is the UK Jurisdiction Task Force. This is a group in England chaired by Sir Geoffrey Voss, the Master of the Rolls, whose remit is to examine the common law and to see whether and how it can accommodate novel technology, ideally without the need for special legislation. And our first project was a document called the Legal Statement on crypto assets and smart contracts. Here it is. It was, I commend it to you if you haven't read it. It was intended to examine the state of the common law in two areas. One, the proprietary status of crypto assets, and the other being the enforceability of smart contracts in the common law. And our conclusion was first, crypto assets were property, and that smart contracts were indeed enforceable as contracts. And this was a slightly unusual project in the sense that it wasn't, the statement itself didn't have any binding authority at all, and it wasn't formally endorsed by Sir Geoffrey Voss. He commissioned it, but it wasn't his opinion. Although as Simon said, it has been subsequently approved, at least as far as the proprietary side of it is concerned, in courts in England and New Zealand and elsewhere. And as regards smart contracts, we said that in principle they were enforceable like any other contract. Although, again, like any other contract, one's often going to have problems in identifying precisely what the terms of it are, particularly in the crypto context, if the only thing that's actually been, I won't say put down on paper because it's not been put down on paper, the only thing that's been recorded is the code in the smart contract itself. And that obviously leads to some difficult questions about what the terms of the contract are and whether they are contained in the code or whether they can bring in external things as well. Now, after this first legal statement, the UKJT started thinking about dispute resolution and how some of these issues around crypto assets or disputes around crypto assets and smart contracts could efficiently be resolved. And we obviously considered that arbitration in that respect had a great deal to recommend it. Why is that? I mean, there were obviously some commercial drivers. There is, it must be said, something of a philosophical divide, if I can put it that way, between those who design and use digital asset systems and conventional lawyers. There are certainly some in the kind of crypto world who subscribe to the heresy that law has no place to play in the smart contract and crypto asset world, because they say, and the expression is sometimes used, code is law. That because everything is subject to strong cryptography and automated transactions and everything is controlled by the software algorithms, there is no need, they say, and perhaps no ability for humans to be involved at all in the process other than in coding. But that's, in my view, certainly not correct. It's always open to a person who has been affected by the operation of a crypto asset or smart contract system to say that it's been unlawfully prejudiced in some way, by representation, by coding error, by whatever it is, by a failure of a counterparty to do what it had promised to do, and to bring such claims before a competent court or tribunal. But even so, I think those in the digital world had a perspective that existing court systems were too cumbersome, too slow, too paper-based, too legalistic, too expensive. Some, I think, perhaps didn't have complete confidence in the technical knowledge of some judges using typical processes. And again, I mean, a particular feature of these transactions is you're dealing with potential users who are operating without any particular link to any particular jurisdiction. And there'll be real issues if in a court situation about which court is appropriate. Because it's in on jurisdictional grounds, because it's in the nature of a smart contract or crypto asset that the parties, I mean, not only will they be in different jurisdictions, they may not know each other's identity, either at the outset of the trade or ever, and they may never find out each other's identity. The assets themselves, let's say a Bitcoin or another kind of crypto asset, if one's trying to look to its location as a way of establishing jurisdiction, to its citers, that's a very difficult question. These assets are not only intangible, but they exist within entirely decentralized systems, which have no readily identifiable geographical connection. So, and I mean, and that itself has been a subject of considerable debate in the English courts, particularly in a recent case called Tulip Trading and Bitcoin Association, about where, for the purposes of choice of law and jurisdiction, a crypto asset should be treated as located. And the current state of the law, at least in England, is that it should be treated as located as where the owner of it or the holder of it is domiciled. But anyway, there it is. I'm sure courts of other countries will come to different views. But I mean, that uncertainty underlines the advantage, of course, of the parties and the importance of the parties agreeing dispute resolution techniques in advance, and of course, looking at arbitration as an option with all the advantages it has. And at the UKGT, and obviously there are many existing institutional and non-institutional arbitration systems for people to choose from. But at the UKGT, we thought that there was potentially room for either improvement or at least an alternative from some of the conventional systems, some of which suffer from some of the same and unattractive features of court systems as regards time taken and the use of paper and so on. But a particular factor in play was that smart contracts and crypto systems may raise some novel issues and novel opportunities as regards the process of dispute resolution. So to just take an example, some crypto systems have a form of dispute resolution coded into them. For example, the smart contract might have a kind of special private key which allows it to be cancelled or completed by a third-party adjudicator. So the third-party adjudicator can actually directly control the operation of the smart contract. And there are some systems, for example, that have a system of, if a dispute arises, there is a process of consensus voting on the blockchain where a dispute is put to a panel of users, jury it's sometimes called, who vote through the blockchain on what the answer should be. And the result is automatically implemented in the blockchain. So these are some really interesting and novel dispute resolution techniques, which really only arise because of the novel nature of blockchains and crypto assets. I mean, some really interesting and quite sophisticated developments of that, for example, where you have a jury system and your vote on the jury is, or the weight of your vote on the jury is affected by how often you've previously proved to be right, and so on. So, so there are new ways of resolving disputes. And another issue that arises is if you've got a dispute resolution process, how do you attach that process to digital tokens when they are being traded on a kind of quasi-negotiable system, quasi-negotiable basis within a blockchain system, possibly without formal contracts? How do you achieve a situation where whoever ends up holding the token is able to rely on and indeed is bound by the dispute resolution system selected within the token? And then another issue, as I've mentioned, is how do you deal with disputes where tokens or smart contracts are held anonymously? Those were the points that we had in mind in trying to devise some new arbitration rules. And what we had in mind is that obviously the rules could be implemented in a conventional way where the parties just sign up to a bilateral contract at the start of their relationship, and that will be relatively conventional. But also the aim of the rules that we were looking at was to allow also for someone who, let us say, was designing a new public blockchain-based trading system with tokens representing money or contracts. And we had in mind the possibility that the designers of the system might want to incorporate within the tokens and the smart contracts on the system a particular set of arbitration rules. So if there were later a dispute about what should happen to a particular token or contract, the rules would apply automatically to its resolution. Anyway, that was our goal. I'll just here they are. I just share my screen. The digital dispute resolution rules, which again I commend you to have a look at. They are. I mean, I should say before I go any further that we launched these rules a little while ago, and as far as I'm aware, no disputes have actually been arbitrated under them yet. And I don't have any information as to whether there's been any take-up of them, and whether there has been or will remain to be seen. But they are at least, I think, worth looking at, just if nothing else, to see what kind of arbitral issues might be thrown up, and we put them together after some quite extensive consultation, both in the legal and technical worlds. We tried to make them absolutely as short and as non-legalistic as possible. They run to, I think, no more than that's clause 1, and no more than I think 11 clauses. No, sorry, no more than 16 clauses over just a couple of pages, and they are deliberately both short and also intended to give maximum discretion on the arbitrators in terms of procedure. Default timetables are very, very short. Again, deliberately in contrast with typical arbitration procedures, and the idea being that the tribunal will take control of the case at the earliest possible stage and to fashion an appropriate procedure and timetable. But just to highlight a few novel features of the rules. First of all, the rules recognise and give effect to automatic dispute resolution processes built into systems. And that, for example, the kind of jury voting or algorithmic systems that I mentioned before. So in other words, if you've got a smart contract that has coded within it some mechanism for resolving disputes, then that will be given binding legal effect under the rules. The other novel feature is that where a digital asset system provides for it, arbitrators are able to implement their decisions directly on the blockchain or within the system using any private key or control mechanism that's been made available to them. And what that has in mind is the idea, as I mentioned before, that it's possible to code. So a smart contract will operate to make a transfer or not make a transfer in accordance with its code, and a simple smart contract will simply do or not do something depending on whether some particular condition has been met. But you can have and of course that can't be changed, because once the smart contract is on the system and has been digitally signed with its own private key, that is immutable, like any other transaction on the blockchain. But it is possible to have a slightly more sophisticated smart contract that has another private key, which gives control over it, which acts as a kind of, you might say, kill switch, or a mechanism either to confirm a transaction or cancel a transaction. And so you can have a smart contract where one of the parties has an option to register a complaint or register disputes about the operation of the contract. And when that happens, the smart contract automatically pauses. The dispute is automatically then referred to a human arbitrator who conducts an arbitration in a conventional way, works out what the answer is, but then can automatically implement the award because the arbitrator has been issued with the private key available only to the arbitrator, which effectively allows him or her to cancel or complete the transaction in accordance with the award. And so that's an interesting possibility. And again, that's something the rules provide for. They also provide for, or seek to provide for the possibility of making the dispute resolution procedure binding on all parties who are interested in the relevant digital asset, to allow assets to be traded on a blockchain, carrying with them, as it were, the dispute resolution procedures. And the other thing the rules allow for is that in an appropriate case, it may be possible for the parties to remain anonymous to each other while conducting their dispute, although, of course, they must disclose their identities to the arbitrators. So those are some of the novel features we incorporated in the rules. And we did that explicitly recognizing that some of them might be regarded as rather controversial, particularly the one about anonymity, and recognizing that there would need to be further thought and potentially further consultation about how one would actually implement them in a practical way. For example, just going back to my idea of the arbitrator having their own key to execute their own private key to modify the blockchain to execute their award, there would need to be some process by which that key was provided to the arbitrator in advance of the dispute. So we'll need to plan these things quite carefully. And of course, the other thing is to make one can only implement this idea of a very rapid dispute resolution if you have essentially instant access to fully qualified, technically qualified arbitrators. And to that end, these rules were issued in collaboration with the Society for Computers and Law in the UK, who have a roster of arbitrators who essentially agreed to pick up these disputes as and when they are notified. And I should say, just in relation, I mean, again, touching on this issue of executing awards, I mean, that's a particularly interesting concept in this area because, and I just need to say something about enforcement. And I don't mean enforcement in the sense of converting your arbitral award into a judgment, but practical enforcement. In other words, how do you actually, if you've got an arbitral award, if you've got a judgment, how do you actually recover the crypto assets that are the subject of it? Because in the world of conventional assets, we are accustomed as lawyers to enforcing judgments or awards against recalcitrant defendants through third parties or intermediaries. So if we have a judgment for payment of money, we look to the defendant's bank to seek an attachment or a freezing injunction. Or if the case is about real property, again, we look to an attachment to the property or against the registry or an inhibition registered against the title. So we have external parties who can assist us in enforcing the award. Now, in the world of crypto assets and smart contracts, there often are no third parties or intermediaries. And I return to the point that I made at the beginning, that in all of these structures in smart contracts, in crypto assets, the private key is the beginning and end of the right to control the asset or to control the operation of a smart contract. If my crypto asset has passed from my address to another address, there is no way of recovering it without the private key of the destination address, and no means of obtaining or recreating that key without the creator of the address telling me what it is. And of course, one can get a court order backed by contempt sanctions or whatever, but if the defendant is out of the jurisdiction or dead or not cooperative, there's only so much one can do. And I mean, one might think about it this way: one cannot reverse a smart contract without the private key any more than I can get my coin back out of the vending machine. At least not, I can't do that without a sledgehammer. And in the crypto world, the cryptography is so unbreakable that there is no equivalent of the sledgehammer. So I mean, I'll just wind up with a couple of conclusions from all of this, and in particular, just to think about what it is that potentially makes disputes about crypto assets and smart contracts distinctive. I think we can identify the following things. One is anonymity. A second is in relation to some smart contract arrangements, the lack of a counterparty. And again, you remember the example I gave of the smart contract where you're just trading with the software, you're not trading with another person. A third one is what I call, and what at the UKJT we call automaticity. In other words, the fact that transactions are completed automatically by a software algorithm and without the need for, and indeed without the possibility of, human intervention or human decisions. Fourth one is immutability. In other words, the fact that once something is on the blockchain, it cannot be changed. And finally, the point I was making a moment ago, the restrictions on practical enforceability of judgments and awards against uncooperative defendants. So those are all features which I think one has to think very carefully about as to how those kind of disputes would be resolved. And ideally, for your clients to think about those before they enter into the transactions rather than afterwards. And if you have the luxury of considering the points in advance, arbitration seems to give you the ability to set the rules in an appropriate way, and perhaps most interestingly, the possibility of integrating the arbitration process within the smart contract. So that's what I was going to say by way of just speaking to you. I'm happy now to take any questions or any comments. I see I've got two already.
Yes, I think there are two questions already.
Yes, I don't. Can everyone? I don't know. So can everyone see these questions, or should I read them out?
I think it's better to read out.
Okay. So the first one, the question is a very interesting question. Since the parties to a crypto dispute can be anonymous without knowing the identity and jurisdiction such parties are subject to, how can a party even start a legal action without such information? Well, just thinking first of all about court proceedings. In England, there is what's called a persons unknown jurisdiction, which is that you can bring an action against someone by description without knowing their identity. So, for example, you can name the defendant as the person in control of a particular asset. So you can do it procedurally. Of course, you then run into the practical problem that once you can get a judgment against them, but if you don't know who they are, how do you go about enforcing it? And that's an inherent problem in blockchain systems. If you don't know who they are, you can't find out, and you can't otherwise find out their private key. You're essentially stuck. But a slightly different issue arises, and this is what we were focusing on in the DDDR, is where you have parties who are not uncooperative. They're happy, they have a dispute and they want it to be resolved, but they wish to remain anonymous in the course of that dispute unless their identities have to be disclosed. And one of the ideas in the digital dispute resolution rules is that if the parties have agreed that in advance by signing up to the rules, it should be possible in principle for them to put their dispute without disclosing their names to the arbitrator. So the arbitrator will know their names, but their names won't be disclosed to each other. And for the dispute to be resolved without disclosure. And so that, that was a novel idea that we tried to introduce in the DDDR. Second question, also very interesting. How would one safeguard a party's right to challenge the award for procedural error if the arbitrator has been given a private key and has already implemented the award by using that key. That's interesting. I'm not sure I thought of that one before. I suppose the answer to it is that you would you'd still be entitled to challenge it for procedural error, and I suppose that the supervising court would have the power to set aside the award, and if necessary, to make consequential orders for the award to be reversed, if that's possible. But it may be that in practical terms, it couldn't be reversed if the arbitrator refused to do it, or if the private key only worked once. And again, that is a feature of the system, and it's a risk that people have to think whether they're prepared to take it in giving the arbitrator that. I think also there is there someone who had their hand up as well? Jay Chia. I think I can. If you got your hand up, can I allow you to talk? Is that
yes, I think.
Yeah. Hello.
Yes. I think
Hello.
she's mute her voice.
Oh yes, you need to unmute.
Yes, already unmute. Already
Okay.
asked to unmute. Maybe.
No, that doesn't seem to be working.
Maybe
I think
here.
no. Okay. All right. Never mind.
They give him some time to deal with this. Is it possible for? Let me ask him to unmute.
Okay. In the meantime, if anyone else has got any other questions, do put them in the chat. Otherwise,
Yes. Anyone feel free to ask any questions. Actually, I can think of an example about the parties unknown jurisdiction, which David has just mentioned. Actually, I think there's a landmark case in UK. There's actually quite a number of these cases about the claimant being a victim of certain ransomware virus.
yeah.
And after, the virus encrypts the users' files and they demand the payment, and then the claimant pay the ransom by transferring Bitcoins. Of course, they didn't know who are the parties, and then they employ some investigators, and the investigators are able to trace the Bitcoins to a link, say for example to a exchange, a Bitcoin exchange, crypto asset exchange. And then the claimant can actually sue the persons unknown, which is the ransomware virus people, and also the exchange, and they can just ask for freezing order or injunction, proprietary injunction.
That's you're absolutely right. So there've been quite a lot of those cases, which, as you say, follow a sort of similar process where they sue a person unknown. They try and trace the just so everyone appreciates that. So I mean, one of the features of these ledgers being public documents is although they're anonymous, you can do the tracing exercise quite easily. And as you say, if they're traced to an exchange is act kind of a little bit like banks in the crypto world, then you can ask the exchange for information about who its customer was, and that might give you an angle to find out the identity of the fraudsters. There is also, as you say, a most interesting and important question about whether the exchange itself has any liability in these cases. But there's not very much I can say about that at the moment because I'm acting for one of the big exchanges on exactly that issue. So, and that's to be determined probably in the course of next year. So I better not say anything about that at the moment. But there is a very important question about the liability of innocent recipients so the liability of innocent recipients of crypto assets. And in particular, I mean, and just to flag this point for you all to think about, because it's a very interesting question, but how the law should deal with title in relation to crypto assets, because if someone steals my car and sells it to someone else, I can recover title in the car, even against someone who was a good faith purchaser, because I retain legal title and the thief can't give title to someone else. But if someone steals my money, puts it through their bank account and pays it to someone else, and they receive the money in good faith, I can't assert title to the money. So I'm the loser there. And there's a very interesting and important question as to whether crypto assets should be analysed as, in that example, as being more like a car or more like money. And that remains to be seen.
Mr. Polo, you can allow to ask the question.
Yes, thank you very much. Extremely interesting speech, I must say. I have a follow-up question to my question regarding the challenges in case the award is already de facto implemented by the arbitrator using the private key. Do you think there is any additional issues as to arbitrator liability here? I'm thinking of the fact that usually, of course, most jurisdictions, there are exceptions, but most jurisdictions require bad faith on the part of the arbitrator or intentional damage for the arbitrator to become liable. But if the parties have given the arbitrator a mandate to use a private key, maybe that mandate has to be exercised with normal due diligence, so to speak. Maybe the normal arbitrator liability rules don't cover that situation. Do you have any thoughts on that?
It's an interesting thought. I suppose it would seem to me surprising that if the parties had expressly agreed that the arbitrator could implement the result of the award using a private key, and that's what the arbitrator did, it would seem to me very difficult for the disappointed party to say that gave rise to any liability, because the arbitrator is only doing what the parties had expressly authorised him or her to do. I suppose that the practical answer to the question is probably that if someone is suggesting that you be appointed as an arbitrator on terms that you will have a self-executing award, you should probably make sure it's written into the terms of your appointment that you don't have any liability for doing it. But it would seem a difficult argument to say that the arbitrator should be liable for doing exactly what they've been instructed to do.
Thank you. Have you seen any specially tailored arbitrator appointments term for these kind of disputes?
No, I haven't. And I mean, to be perfectly frank, I haven't seen any arbitration either at the dispute level or in terms of the sort of documentation level, contemplating that kind of arrangement. And I think that's very much something we're looking towards in the future. I don't think it's a current problem, but what I will say is that knowing, having spoken to people who were in the sort of business of designing these technical systems, I think there is a lot of interest in allowing for disputes to be resolved on chains, as they put it. In other words, allowing for the dispute resolution mechanism to be incorporated in some way within the crypto asset system. I think it's very much, if I may say, in that respect, for the lawyers to catch up with the technologists.
Thank you.
Now, there's another question on the Q&A, which is, where is a consent to arbitration where the arbitration clause is a coded smart contract that cannot be identified by a user? Again, a difficult question. As I think I mentioned, one of the one of the goals of the rules was to try and make them applicable in negotiable transactions, and so to sort of travel with the token. We did recognise, though, that potentially presents some rather tricky questions of contract and privity, to which I'm not sure I know the answer. But I mean, in many cases, the problem, it'll be simpler than that, because in many cases, I mean, if you've signed up to participate in a smart contract, in other words, if you have, let us say, engaged with the smart contract, I can put it that way, by, let's say, transferring your asset into the smart contract to be dealt with on its terms. I think, and if the smart contract says, within its code, or within the human readable part of its code, any disputes will be resolved in this way. It seems to me that you've agreed to that mechanism, and you'd be bound by it on the ordinary principles of contract. So if that's what you mean, then I think, in most cases, the very fact that you've engaged with the smart contract will be treated as your consent to the dispute resolution clause in the smart contract. I mean, you maybe ask a slightly different question, which is, how do you deal with smart contracts which are only code and don't have any human readable part at all? And that creates its own difficulties. But ultimately, again, I think if that's all there is, if the code is all there is, then a court or arbitrator is going to have to do their best to work out what it is the parties have actually agreed. Yeah. Well, yeah. I mean, if it is only code, then you have a sort of broader question of trying to work out what the parties have actually agreed by that. But I mean, in principle, as we said in the first statement, the terms of the code can be the terms of the contract. All right, I think that's probably, unless there's anything else.
No.
Is there any more question? Well, if not, well, thank you very much, Paul. David, thank you very much, David, for your wonderful sharing. Thank you, everyone, for attending to today's webinar. And I think that's all for now.
All right, well, thank you all for listening.
Thank you.
Thank
Bye-bye.
you. Okay, David.
Bye.
Bye-bye. Have a good day.
Have a good day.
Bye.